All right, Mr.
Okay.
Executive Director, I will call the meeting to order. Do we have a quorum?
I'd like to call a roll to establish a quorum because we do have some absences today. So in alphabetical order, Commissioner Carrillo,
Present.
Carrion,
Present.
Hebner,
Present.
McAllister,
Present.
Simpson,
Here.
and that's 5, and that's our quorum.
Very good.
Yeah, we're
First item.
expecting that Kara Jenkins might be able to join us later in the day. She had a conflict this morning, but Anna is not able to make it. Neither is Victor.
Should we take our first item?
I think we should.
Okay.
That's the
Approval of the minutes.
memo 2313 presenting the minutes. Staff has no recommended revisions.
So move.
Any second?
Second.
Any discussion? Going once, going twice. Can we call the
I
roll?
will call the roll. Carrillo,
Aye.
Carrion,
Aye.
Hebner,
Aye.
McAllister,
Aye.
Simpson.
Aye.
That concludes that item.
Next in order.
Well, we were gonna skip ahead to antitrust to provide as much time as possible for Professor Green to make his presentation. We have a time certain at 11. Dean Erwin Chemerinsky is going to be joining us, and he's only available for a short time, so I don't want to delay his start. So
Sounds
with the
good.
commission permission, let me introduce again Tom Green, and I will get ready to start his slideshow.
All very nice to be with you again. Brian's going to help me with the slide deck, but we did cover a lot of ground last time. Are there any questions, issues? Oh my God, what was that guy talking about? Any questions or thoughts?
Is your presentation gonna link with the current banking crisis in any way?
No, unfortunately not. Antitrust is a very broad and capacious area of the law, but Silicon Valley Bank, as far as I know, we don't have.
It's out of your jurisdiction.
Yeah. So today's topic is monopoly and monopsony. Next slide, if you would, Brian. So back one. As always, disclaimer, two disclaimers this time around because I just need to be complete. One is I do not speak for the U.S. Department of Justice, which is my current employer, nor do I speak for UC Law San Francisco, formerly UC Hastings in San Francisco, where I teach antitrust law. Next up. So today's agenda, we're going to cover the major elements of federal antitrust law, and those are monopolization, attempted monopolization, and conspiracy to monopolize. I'm going to give you a very quick overview of what I think are the key cases and some of the issues. There are a couple of cases with respect to predatory pricing and duty to deal, which you are going to hear about from various sides of various antitrust debates. So I want to at least expose them to you, the basics of that conversation. You asked for a very brief overview of abuse of dominance. Brian and I are still working on finding you a good presenter on those precise issues, but I'll give you an overview with some citations to material. So if you're really interested, I'm going to give you some places to go look at the European system. We're going to talk a bit about gaps in current California law. Basically, we're going to be talking about single firm conduct. California law maps to this area of federal antitrust law very imperfectly. There are kind of left-handed fixes and ways to address this, but it's not like there is a version of Section 2 in the California Cartwright Act or anyplace else. So we'll talk a little bit about that. I think you need to know about that. You need to obviously make a policy decision whether you want to do something specific with single firm conduct, but you need to know what California law does, at least at a high level. I want to spend a few minutes on what I call here buy-side antitrust. So antitrust can deal with the selling of stuff. Microsoft sells you an operating system. Microsoft also purchases things in the market. So you can, and probably will want to, look at both sides of those kinds of activities. One's a buy side, one's a sell side. Usually when we think of antitrust, we think of sell side stuff, but antitrust law also applies to buy side transactions. So very brief history, what monopsony is about, and some recent cases and issues. So next slide. So just so we're clean on nomenclature, the word monopoly is actually an old one. Sir Thomas More, I think I showed you a portrait of him, gave guidance to Henry VIII, amongst other people in England during his time. He was part of the English Renaissance and wrote a book in 1634 in which he apparently created the word monopoly. This is from the Greek. Mono means only or one. Polein is the Greek second portion of this, to sell. So single seller is the deal. That's the source of monopoly. Monopsony is the other side of that. This is a much more recent word. This was first seen in a book by actually a wonderful economist, Joan Robinson, who was a Cambridge economist and did some very early incredible work in terms of imperfect competition. Up until her time in the 1930s, people thought of perfect competition where everything works in a perfectly competitive way, or monopoly. Those were the two extremes. She began to explore in a thoughtful way the middle, which is where a lot of interesting things happen. She asked one of her colleagues at Cambridge to give her a word that would be like monopoly, but it would be on the buy side process. She was in particular an economist that focused on employment markets. So monopsony means purchase. It is intended to cover single purchasers of inputs and mostly employment. And then the third word, which you need to be aware of, is monopolization, which is what I deal with as an antitrust lawyer and as an antitrust prof. Monopolization is one of the key elements of Section 2 of the Sherman Act. So that covers both buy-side and sell-side transactions, but it's primarily focused on single firm conduct. Next slide, Brian. Next slide. So this is the text. I show this kind of a slide frequently to my class, but I'm always struck. This is the crucial antitrust law, and this is the underlying text is the text. I mean, federal law, Section 2 of the Sherman Act forbids every person who shall monopolize or attempt to monopolize or combine or conspire with any person to monopolize. It's unlawful. Though there isn't a definition of monopolize or any of these other terms, this is the law, the federal law, and then there's 1,000 cases interpreting these, but this is the original statutory text, and this is still the text that we apply at the federal level. Now, the key here, just to remind you, Section 1 deals with conspiracies or combinations in restrictive trade. So you need two people, at least in a Section 1 case, what is the sound of one hand clapping? In that space, nothing. Section 2, on the other hand, does deal with single firm conduct. So a single firm, think of John D. Rockefeller Standard Oil Trust, that is actionable and was intended to be actionable under this section of federal antitrust law. So I'm going to talk about both the monopolized portion of this and the attempt to monopolize portion. Conspiracy I'm not going to cover in any actually at all because it's so close to Section 1 type stuff that it's not distinct enough to really sort of cover in what is actually a very compact presentation to you on Section 2 analysis. Next slide, please. So a very brief timetable. Recall, Section 2 was passed in 1890. Overwhelmingly approved by both Democrats and Republicans at the time. Senator Sherman was a Republican. This was in the platforms of both parties at the time, so a very big deal. Not until Standard Oil in 1911, this was a case originally prompted by Teddy Roosevelt. It articulates the rule of reason, and it's the first initial development of Section 2. This leads to the breakup of Standard Oil into its various constituent parts. We currently see that Standard Oil of California is now Chevron. So the progeny of this case still exist in the forms actually that they were largely birthed from in this case. U.S. Steel, much more permissive approach. This is the beginning of the go-go years, the 1920s. Then Thurman Arnold, who we talked about, a very important person that headed up the antitrust division late in the administration of Franklin Delano Roosevelt, begins filing a whole series of cases. These bear fruit after he leaves. Lorraine Journal is a case that is very important to us. Alcoa, we've talked a little bit about. This one basically creates what's called the power conduct dynamic. So you got to show market power, and then you got to show bad conduct. We then get into the world of the Chicago School. I've described this to you through the lens of Robert Bork's work. He's not alone, obviously, but deep skepticism about exclusion theories, which is what mostly Section 1, Section 2 is about. Key cases, Brook Group and Trinco. These are cases that you will hear about from your respective specialty committees, probably. So I'm just going to very briefly touch on these two cases. And then the post-Chicago pushback. Aspen Skiing is a duty to deal case. And then Microsoft, which I'm going to describe in a little bit of detail, because I think this is really the litigation structure that I, as a federal antitrust lawyer, and we who work in the federal space deal with on a regular basis. So there's burden shifting, there's how do you determine whether there's monopoly power, et cetera. So next slide. Okay, Microsoft decided 2001, got off the ground actually in the very late 1990s, very aggressive litigation schedule. This is a light speed case, particularly for something as complex as Microsoft. So a huge success in terms of being able to move an important case forward quickly. And lots of new learning in here, or at least the explication of learning that had been floating around in various cases in a very specific context. So next up. So my apologies for this, lots of text. You can come back and look at this, but basically a few ideas. One is this updates the Alcoa power plus conduct paradigm. You got to show power, you got to show bad conduct. Power, there's now a more interesting and more complete way of thinking about how to determine whether there's power. Firstly, there's direct evidence, and I'll talk to you a little bit about how that's determined. And then secondly, circumstantial evidence, that being specifically whether a particular defendant has a big share in a relevant market. So market definition and a high share within that market becomes a big deal. Then the major contribution, I think, of Microsoft was what's called the burden shifting framework. And we'll talk about that a bit. Essentially, plaintiffs need to show that there's bad stuff going on. If they do that successfully, the burden shifts to the defense, who's given the opportunity to say, no, that's not a good way of understanding the world. This is actually pro-competitive, and here's why. And then the burden shifts back to the plaintiff to say, no, that's not correct. On balance, this is ultimately bad versus good. This is a goat, not a sheep. Kind of a deal. And then finally, this is a technology case, one of the most important actually in the canon at this point. One of the things that Microsoft was attempting to do was to suppress a nascent competitor, that is somebody that was just getting off the ground, and that those two competitors being Netscape, which was an early browser, and Java, and that was a threat potentially to Microsoft, and they were crushed. They were not a big deal at the time, but they could have been a big deal. At least that's what the court thought. So nascent competitors can be considered important aspects of a Section 2 analysis. Next slide. Okay, so just very briefly, this was from Microsoft's perspective, at least Bill Gates' perspective, a disintermediation threat. That means Netscape, Java could basically either eliminate the demand for Windows or dramatically reduce its value. So the idea was, and I don't want to get technical with it, there's things called APIs, application program interfaces. So think of these as like little wires sticking up from the Microsoft operating system. Instead of writing code to do a bunch of stuff, you just plug into one of those wires, and you send that, have your application send a signal there, and that will do what that wire is connected to doing. The concern that Microsoft had about Netscape in particular is that application builders would begin building to the little wires or the APIs in the browser, which would then make Microsoft's OS a commodity. Because one of the foci of Netscape and Java was to create platform agnostic systems. So you wouldn't have to worry whether you were writing for something that was ultimately based on Windows or Apple or something else. You could do it all through, or at least that was the threat, all through this intermediary middle layer of code. And this is a memo, this is from a memo which was reproduced and available on the Justice Department website. This is called the Internet Tidal Wave. This was a very key piece of evidence in the case. And Bill Gates wrote this talking about how important these new born on the internet competitors were and what they could potentially do to the value of Microsoft. Next slide. So the first step in this process is, again, going back to Alcoa, market power. So you can do that with direct evidence. And this is a quote from Microsoft quoting another US Supreme Court case called Grinnell, is the monopoly power is the power to control prices or exclude competition. So the power to control price or exclude, typically you control price by successful exclusion. So the court goes on to say, more precisely, a firm is a monopolist if it can raise prices substantially above the competitive level. Now, in a merger, you couldn't tell, this is impossible because they don't control the company they want to control in a purchase. This kind of direct evidence, however, is frequently, if not usually, available in conduct cases. So in monopolization cases, the ability to discover and present direct evidence of monopoly power is certainly part of what one does in these kinds of cases as a plaintiff. Next slide. So the other way to do this, and when we have a conversation about mergers and acquisitions, this is the way you'll figure out whether, or this is how courts figure out whether there's monopoly power. So you define a market, and then you determine what the share is of the potential defendant in that market. So here, the court defined the market as the market for PC operating systems. Within that, just looking at the very bottom, Microsoft had a 95% share, and that share was protected, that's the bit in the middle, by something called the applications barrier to entry. So the idea here, and again, not to drag you into tech, is applications. So if you are a builder of applications, you want to build to the most popular OSs. I mean, if you're going to build, you want your application to work on big things as opposed to smaller things. You will, as you get more involved, you will also want to do maybe 6, 2, and 3, but you definitely want to do number 1. And then users, when they are looking at, am I going to buy a Microsoft system or say an Apple system, I want to make sure that I've got all of the useful apps to me, and I want to be able to think about apps in the future. So these two things work together. And if you can't have apps, then your system will be less competitive. And at the time, Microsoft was by far the most significant platform for applications during the late 1990s, obviously still is, but that was an important aspect. Next. So just a little bit of this is almost a footnote on that first bit. Market definition is a gigantic deal, often unsung in these kinds of cases. So the deal here is that current case law, which I've got a slide on, you need to show a roughly 60+% share of a relevant market. And the way that is ultimately determined, the key first step is the frame. What's in the market? So if I can frame my case as one in which there are only 2 people in the market and there's a merger of the 2, then you're going to get merger to monopoly. But the defense, of course, wants to make sure there are as many other things in the market as possible. I mean, that's the kind of game that we play on both sides of the aisle. So the best example of that, at least one that seems to work by students, is that there was a proposed cola merger in the 1970s. And so there, from that experience, people sort of describe something called the Lake Erie defense. So, okay, 2 cola companies want to get together. Okay, cola. Well, do you also want to include all carbonated beverages? Yeah, maybe. How about other cola beverages, all carbonated beverages? So is Mountain Dew in the market, for example? Do you want to include all fruit flavored drinks? How about bottled waters? And if bottled waters is in the market, then maybe all tap water is in the market. So offense, defense, the offense is going to be trying to say, no, people who like cola drinks don't drink Mountain Dew, so it's cola. If you're on the defense side, drinking liquid is liquid, so anything liquid is in the market. So this framing is crucial to the ability, doing this properly from the plaintiff side and the defense side is crucial to being able to find this market share, which is crucially important. There are econometric tools if there is prices involved. Cross elasticity of demand is kind of a touchstone for this kind of stuff. But basically, there are ways of doing this. But it is the case that this is a big deal. Next slide. So this is just 3 cases that I think are fairly useful in terms of, okay, assuming you've defined a relevant market, what is the actionable percentage under Section 2 to prove monopolization? So this Marshfield Clinic thing, this is by a famous 7th Circuit judge, 50% or less, not enough. The Eastman Kodak case, this started in the 9th Circuit. 9th Circuit said 65% share generally required to establish a prima facie case of market power. That was supported in the US Supreme Court when it went there. This is a little thing from a frequently cited set of reference books, the Antitrust Law Developments by the ABA section of antitrust law. And their suggestion is greatest uncertainty exists when market shares are between 50 and 70%. So this share business, big deal, because there aren't that many companies in the world. And that's, that was part of the policy fundamentally. There aren't that many that would meet this first element of the test. So be aware of it. Next slide. So the other element here is exclusion. And these are various formulations from various times and places and cases, but probably the most decent is the one in the last position. This comes from a case called Aspen Skiing, and they quote Arita and Turner, who were, and this book is still very important to antitrust lawyers, exclusionary comprehends at most behavior that not only one, tends to impair the opportunity of rivals, but also two, either does not further competition on the merits or does so in an unnecessarily restrictive way. So this kind of gets at how you might think about assessing some specific form of behavior, which at least a rival might think is restrictive and arguably actionable under Section 2. Next. So one of the really useful aspects of Microsoft is to sort out a process by which one can try and make that actually quite elegant and pretty challenging judgment as to whether something is exclusionary or not. Is this a sheep? Is it a goat? So the first step is one that has to be traversed by the plaintiff. You need to show your theory of harm and harm to competition, not simply to competitors. So going back to a case we talked about last time, then step 2, establish anti-competitive effects. Then the defendant can respond, giving pro-competitive justifications. And then the fourth step in this process, the plaintiff can establish that the anti-competitive harm outweighs pro-competitive justifications. This last bit can be more complicated. In some cases, the pro-competitive justifications are arguably pretextual. You examine the emails of the defendant and they really weren't trying to improve efficiency. They were trying to kibosh their major rival. That kind of evidence comes in here as the court is assessing the purported pro-competitive justifications. But this process is a useful one for courts and lawyers on both sides of the aisle to use. This kind of looks like it could be sort of a tennis match. As a plaintiff, I bat one over and say this is anti-competitive, and then the other side bats one back to me saying no, it's pro-competitive. In my case in chief, if I'm a plaintiff, I will cover all of these bases, and then the defendant will try and cover all of the bases when it gets in front of the court and the trier of fact. So, but these concepts are very much crucial to this process. Next. So in Microsoft, there were, and I'm not going to read all this stuff, but essentially there was a combination of restraints. One were exclusionary contracts. So there were various contracts with essentially the two major channels of distribution at the time. Original equipment manufacturers, there would be contracts that Microsoft entered into with them to put its technology on the machine so when you open the box, you would get the Microsoft product. And then there were also technical restrictions. The most significant was one which basically said original equipment manufacturers couldn't suppress or make invisible the Microsoft Internet Explorer technology, which meant that they couldn't get away from Microsoft's access point to the internet and substitute other competitors. So some exclusionary contracts, some technical restrictions. Next. So that shifted the burden, and the first defense that Microsoft made was they have an absolute and unfettered right to use their intellectual property. Court said, no, that's not correct. You can generally have that right, but in this case, Lorraine Journal is particularly important on this one. You can't, that freedom is limited by the antitrust laws, which makes sense given the antitrust laws. So that was dismissed. The Microsoft also said it reduced the stability of the platform, and the court, looking at the totality of records, said, no, that's not sufficient, not compelling. But for a few things, the appellate court said, yeah, and on balance, not exclusionary. So courts will go through and pick through in a pretty detailed, actually quite detailed way, trying to sort out what is exclusionary and what's not, and what supports one side's view of these versus others. Next. Nascent threats, I mentioned this a little bit at the beginning. The issue for the court was whether the exclusion is the type of conduct that is reasonably capable of contributing to defendants' continued monopoly power. And the conclusion, which was very policy-based, but very smart, the court concludes it would be inimical to the purpose of the Sherman Act to allow monopolists free rein to squash nascent, albeit unproven competitors at will. So part of this conclusion is probably based on the fact, amongst other facts, that the company, that is Microsoft and Bill Gates, really were very threatened by these new competitors and new kinds of competitors. So nascent threats, at least in the context of these facts, more than sufficient to be an actionable target of exclusionary conduct. Next. So, yeah, go ahead.
Yeah, quick question. I'm the only non-lawyer on the screen here. In that kind of a case with Microsoft, or these other Section 2 cases, what's the burden of proof? I mean, and one of the reasons I ask is because if I recall what you said in Section 2, it says, violating the Section 2 of the Sherman Act is a felony, and is it a burden? Is it a preponderance of the evidence? Is it a clear and convincing? Is it a beyond reasonable doubt?
Yes. If you're filing criminally, criminal Section 2 cases were actually relatively common 40, 50 years ago.
Mm-hmm.
There is now an interest at the current U.S. Department of Justice to revive that jurisprudence. But if you bring a case criminally under the antitrust laws or any other federal law, the burden is beyond a reasonable doubt.
Okay.
So, and the civil burden is preponderance.
Preponderance.
This case was civil in nature.
Okay.
Because of the complexity of these cases, they tend not to be done criminally. But in some circumstances, I've got a case or two for you. We've done more recently at the Department of Justice, where we have gotten, in one instance, a plea to criminal attempted monopolization, but the facts were way easier than this Microsoft set of facts.
Okay, thank you.
Oh, no worries. So duty to deal cases, what does that mean? Okay, so you're a successful large monopolist. Under the policy question is, under what circumstances do you have to deal with a rival? Now, if you are desirous of protecting incentives for monopolists, companies to try and be successful enough to become a monopoly, then that duty to deal should be ablated or reduced. If you see them as so powerful that that duty should apply, then you're going to have a different view of this duty to deal business. So next slide. So just to give you some examples, the classic duty to deal cases, the 1912 case, this was a case in which a dozen railroad companies got together to build a bridge across the Mississippi River. They didn't let any of their rivals in on the deal. And the rivals said, look, this bridge at this place, it was St. Louis, is crucially important to being able to do this, do the business of a railroad, transporting goods across the United States. In that circumstance, this was called an essential facility, and therefore the defendants had to give the rivals access. Associated Press, kind of a similar case. You can see these things, actually, all of these have a network aspect to them, truthfully, so this is sort of interesting. Associated Press, the idea was initially, if you were a newspaper in New York, you would be part of this Associated Press network. If there was a big fire or a big whatever in your city, you would telegraph that story across the United States. There would be AP, other papers, say in Chicago and San Francisco, you would give them your material. That material would not go to any other papers. And the court said in 1945, you do need to provide access. The rivals need to pay for that access, but they got to have access. So that interesting case. If you live in Sacramento or that area served by the Sacramento Municipal Utility District, this next case, Otter Tail Power, this is a case in which a municipal utility district wanted to wheel or transport electric power from generating stations some distance away from the utility across lines owned by Otter Tail Power. So the owner, the utility that owned the line said, not in a million years, we're not going to let you compete with us, municipal utility district. And the court basically said, no, under the circumstances here, you do have a duty to deal. So you in Sacramento get power from Seattle and the Northwest, and it's called, this power is wheeled over lines owned by private utilities and gets to you. And usually it was cheaper. That was why this was of interest. Aspen Skiing is the last of the major plaintiffs' wins in this area. This involved 4 mountains in Aspen, 3 of them owned by one company, 1 of them owned by another. Historically, the 2 companies had combined, cooperated to provide an all mountain pass. And you could go there as a skier, and you could ski on any one of the mountains. And they had a system for making sure that wherever you skied, that mountain would get paid for your activity. But it made it possible for consumers to just go to Aspen and go to any mountain they wanted. The bigger company decided it wanted to freeze out the smaller company, and so refused to provide the all mountain pass anymore. Essentially had a devastating effect on the smaller guy's business, sued. US Supreme Court said under these specific circumstances, highly contextual facts here, duty to deal applies. So next up. Okay, this is a big case, and I mention this because this is a case that currently shapes and controls the duty to deal under federal antitrust law. So your folks in your committees are probably going to raise this with you. So be aware that this exists. And let me just give you a brief overview next. So this involves, again, a network. And the basic setup in the business was that AT&T was sued under Section 2. Consent decree entered in 1982. Divestitures in 1984, they had to divest their local systems. So Pacific Bell was divested, Texas Bell, Southwestern Bell was divested, and AT&T kept the long lines, the long distance service, which is where the most profit was. So one of the aspects of the consent decree was that the local bells had to hook up to all of the various competing long line carriers, the long distance carriers. So it's called the last mile problem. So if you can have a satellite system or microwave towers that go across the Sierra, but you've got to get the phone call from New York across the last mile of copper wire in San Francisco. So the hookup speed and the hookup process between the local utility and the long line service is a very big deal. So the Telecommunications Act of 1996 incorporated provisions of the federal decree, and the Federal Communications Commission and local public service commissions, including the California PUC, were involved in this. Next slide. So Verizon was accused by many of the long distance carriers of not hooking their calls through quickly enough. And there was regulatory action, both the Federal Communications Commission and the New York Public Service Commission fined them for pretty significantly, and said, you've got to improve this because you are injuring the rivals of AT&T in the long line service business. And this case, just to give you just a very brief bit of background, the Trinco is a law firm. It's the Trinco law firm, and this was a class action case, and the assertion was that these activities by Verizon essentially limited choice for consumers and increased the price of telecommunication services to the Trinco law firm and other similarly situated businesses and individuals. So this was a potential class action. It had not been certified at the time it went up to the US Supreme Court. Historically, no voluntary dealings between the rivals and Verizon. So this is a Scalia opinion. And he basically says, look, the duty to deal is very limited, and for these reasons, basically. Monopoly prices are an important element of the free market system, which attracts business acumen in the first place. It induces risk-taking that produces innovation and economic growth. So his idea here is that, look, if you are a monopoly, you've got this wonderfully profitable business, that creates incentives for others to go after you. Whether a case in which the issue was exclusion and denying competitors the ability to compete was appropriate, but this is his sort of notion. And then there's an incentive point here, which is probably the real thing to be focused on. Compelling monopolists to share the source of their advantage may lessen the incentive for the monopolist, the rival, or both to invest in those economically beneficial activities. So the idea here is you want to protect the monopolist in order to protect those incentives, which in turn create good stuff for the economy and for the public. I mean, that's really the analysis here. Next slide. Now, this, you will be not surprised that there's a lot of pushback on this one. And so in particular, given, should I be able to hook up to Facebook if I'm a rival? Should I be able to, and under what circumstances should I be able to sell on Amazon? All of these kinds of tech things raise the issue of the duty to deal and under what circumstances. Now, as a common law lawyer, that is somebody that, tries to make arguments about the scope of cases, one can argue pretty effectively many times that Trinco is not that broad in terms of its actual holding when you look at its very peculiar facts, particularly that it was deal or no deal. It was a totally binary. Oftentimes, dominant companies will want to have deal, no deal, but they'll deal with conditions that may be outside the boundaries, arguably, of Trinco. Trinco also was layered over with regulatory agencies at the state and federal level that would protect this interest that was being protected arguably by the Trinco law firm. But in any case, so there are ways of distinguishing Trinco, but here are a few articles that basically talk about, given specifically high-tech platforms, do we need to make some adjustments in Trinco? So I think be aware that this conversation is taking place certainly in academia, and we're also seeing it in the cases currently. But this is something that you're going to be exposed to and be aware of it. And this is a place in which, you know, you've got competing values, access, potential effects on rivals versus incentives that may be positive for the public. So those are the kinds of extremes that are being discussed here. I like these articles, and they do tend, just a fair warning, to suggest that there does need to be adjustments to Trinco, but you know, Trinco itself is probably its best, the best explication for the pro-monopoly argument here. Next up.
Professor,
Yeah.
I'm sorry, could I ask a question so we
Of
don't
course,
lose
yeah.
this? By titles, the 4 look very interesting. Do any of those, in your view, represent an emerging consensus or an emerging primary view on the issue?
Yeah, I think the answer is probably a soft no. If I were going to recommend one that gets closest to that, I would go with the first one. Yeah, obviously Yale Law Journal, so a good journal. Eric Hovenkamp here is basically saying the historic essential facilities law is being applied both to protect the core monopoly as well as a monopoly's ability to affect. So he talks about the core monopoly, like Apple's phone, for example, being the primary monopoly, the ability to sell applications that work with Apple would be a secondary situation. And he says that there should be different and more strict rules with respect to the secondary portions of this, which actually would be a really interesting way to do it. The nice thing about this particular article is it's the most recent and has a ton of footnotes that are very helpful to just give you a sense of the sweep of this. The second one, the Shalansky-Rogerson thing, they suggest that antitrust by itself is not enough. And so they suggest there should be what they call soft regulation. So they would suggest a regulatory process that would deal with problems of duty to deal that traditional antitrust doesn't do a particularly good job on. The Lena Khan article, Lena Khan, of course, is the current chair of the Federal Trade Commission. Lena's view here is that you should have hard separations between specific aspects of platforms. So she would suggest, for example, Amazon should sell stuff sold by others. It shouldn't sell its own things and be in a position where it can prejudice others versus its own products. And the final one, this is the oldest of them, Spence Waller is basically sort of talking about the need to revive this whole area of the law. So that's the broadest of the perspectives. But I think the first one, in answer to your question, is probably if you're going to read one, I would read that one. Okay, so predatory pricing. Okay, so think John D. Rockefeller historically. So the assertions in the historically were that John D. would cut the price of oil in a particular market until his rival was destroyed, and then raise prices after the rival was out of the business or absorbed into the Standard Oil Trust. So it's a price cut, which is designed to improve the situation for the monopolist and diminish the ability of the rival to either operate or operate effectively. So this again is sort of interesting because we like price cuts. I'm a huge fan of Costco, as are we all. Low price is a good idea, but under some circumstances, and we got to figure out under what circumstances, would price cuts be predatory and anti-competitive? Next slide. So there are various approaches here. One is cost-based. So there's some stuff from Arita and Turner. These guys were based at Harvard at the time, that you should only challenge pricing if the prices are below what's called marginal cost, the cost of producing additional product. In the real world, that's a variable average cost. So that would be a way of trying to determine whether it's a sheep or a goat in terms of reduced pricing. Is it predatory pricing or just price competition? Another thing to look for would be recoupment. Again, think of the traditional John D. Rockefeller situation: cut prices, drive somebody out of business, and then recoup, get back your losses from reduced prices by increasing your prices after your rival disappears. Next slide. You could also take the view that predatory pricing, it should be per se lawful. This is based on the notion that this kind of activity is almost unheard of, and that buying market share is usually pro-competitive. So there's a per se lawful school. The most modern economists would sort of land here in the game theoretic school. Predation and price predation is a rational strategy. It can be effective even when predators' prices are above costs, and predators can exclude equally efficient rivals. So there are various places to land policy-wise here. Next slide. So there are essentially a restatement of what we just saw. Competing priors with respect to price predation in a case called Matsushita, and also in the case I'm going to talk to you about, which is called Brook Group. Predatory pricing schemes are rarely tried, even more rarely successful. It's a key factual premise of these cases. And the article here is by a person named John McGee. He looked at the Standard Oil case, the 1911 case, and said, predatory pricing really was not in the trial record. It's never done. It's not stable. No worries here. So the next bit here is an article from Christopher Leslie. He teaches antitrust law at UC Irvine. And he also went back through the trial record and he said, this is nonsense. Are you kidding? There was lots of price predation. It was very successful, and McGee's work, simply nonsense. So two historians or two historical perspectives on that record. A couple of articles here, I think the one I like in particular is Professor Edlin. Professor Edlin is at Berkeley, teaches antitrust law. Basically he says, look, above cost predation, is cutting prices somewhat, but not so low that you're losing money, can actually be a plausible and effective way to affect the marketplace. So this would be, both of these last two people are probably in the game centric. This is how the real world works, doing that analysis. So that's something you want to be aware of. Next. So the big case on price predation is this one, Brook Group versus Brown and Williamson. Very briefly, next slide. So Liggett, this is a tight oligopoly. There are only 4 or 5 of them, very high profit stuff. Cigarettes are just amazingly profitable. The real profit is in what are called the premium brands, Marlboros, Camel, those kinds of brands. So Liggett share dropped significantly. So then it decided to go into the discount cigarette business. Initially, these would be black and white boxes. And so it would be like 20% off. And it wasn't quite as good as Marlboro, but if you couldn't afford Marlboros, you could get these, they were fine. So Brown and Williamson began selling its own discount cigarettes, and Liggett sues it for below cost sales under the Robinson-Patman Act, and asserts that the reason that Brown and Williamson is doing this is it wants to get Liggett to increase its prices in the discount side because of the big brands want to close the gap between the prices for discount and premium, because people, if that gap is small, people will buy the Marlboros instead of the black and white box. Okay, so there's a whole lot of action going on here, but that was basically what this was about. Next. So the US Supreme Court, another Scalia decision, says you got to show two things. One is below cost sales. They don't select a specific thing, but the parties had agreed that it's average variable cost. So essentially you have to charge less than your costs associated with manufacturing another box of cigarettes. So it's the variable costs. Doesn't include capital costs, basically. And you have to demonstrate recoupment. So there has to be some capability, demonstrated capability to recover whatever losses you incurred when you sold the below cost product. So those are the two elements. Next up. So the interesting aspect from just a current analysis perspective is that the court says you have to show an agreement on how to allocate present losses and future gains among the firms involved. So they didn't precisely say you have to have a written agreement, but the agreement language is in there. So they specifically reject Lickett's theory of competitive injury through oligopolistic price competition. So this gets into the weeds here a little bit. Oligopolies are few, that's an industry with few sellers. And one of the things about an oligopolistic structure is they are aware of each other and change their business practices in light of what the other is doing. In perfect competition, if you have 1 million growers of wheat, what the guy next door in his field is doing is not that terribly relevant to you because you can't control things. However, if it's 3 companies or 4 companies or 5, you can watch each other and you can adjust your activities in light of what that person is doing. So current economists, certainly the ones I've cited to you here, this is Fiona Scott Morton and Herb Hovenkamp. Morton is the economist, will suggest that over the last 10, 12 years, 20 years, the court's statement that this oligopolistic coordination was impossible is just not correct. There certainly could have been coordination. The theory of the case here, at least based on at least some current analysts, is completely plausible and should have been accepted by the court. So causation. Next up. So the effect of this is bad news bears for plaintiffs. Nobody, this is from the textbook that I use at UC Law SF, no plaintiff since 1986 has met the burden of showing those two elements in a price predation case. So predatory pricing, something I think your committees are going to surface to you, and you need to be thinking about, on the one side, price cutting, great idea. Under what circumstances, if any, are we going to allow the law, assuming actually big assumption that you want to deal with single firm conduct, under what circumstances should that be actionable? Next up. So there are some exceptions which are interesting. So there are things called bundle discounts. So next up. Next. So a bundle discount, this case is from the Third Circuit. Our circuit is the Ninth Circuit. Third Circuit basically is dealing with LePage's. LePage's makes generic transparent tape. So it's basically Scotch tape, but it's called LePage's. And that's the only thing they made. 3M makes Scotch tape, in quotes, that's the brand name, and a bunch of other stuff. So LePage's is starting to make inroads, particularly into Staples, Office Depot, the deep discount stores that sell office products, 3M counters with a discounts on a bundle of products. So they take a little snip off a wide range of products, and the effect of that, and then they said, we're going to take this discount, but if you want the discount, you get to buy everything from us, including the tape. So the effect of that was, for the Staples of the world, that bundle was such a good deal, since they did need all of the other things that 3M made, they were prepared to dump LePage's. So the Third Circuit says, look, this is not Brook Group. This is not covered by Brook, because Brook involved a single product. This applies to a broad group of products. And the effect of the bundle is anti-competitive, because clearly LePage's is going out of business, and they are actually cheaper than the Scotch tape that was the springboard for this activity. So bundle discounts, a different rule. Next. This is a Ninth Circuit case. This is in the hospital setting. Next case, next slide. Dominant hospital that provided high-end care, as well as intermediate care and primary care, hospital care services. Tertiary care would be things like, heart surgeries and things of that nature. They had 3 hospitals. The little hospital, McKenzie Willamette, had 1 hospital. It only provided primary and secondary services, but in those services, it was far cheaper than Peace Health. So next slide. So the larger hospital does a bundle discount thing and says, we will, if you want to buy services from us, we will give you a discount that is so good across the board that you will buy from us, notwithstanding the fact that objectively the little guy is cheaper. And then they have a rule about how they allocate these various discounts to the actually competitive portion of the market. And in this circumstance, the bundle discount proved to be unlawful. So these kinds of bundle discount cases basically go half a step to the right from Brook, and that provides actually some support for plaintiffs and gives the little guy, if he doesn't, little guy being somebody that doesn't compete across the full range of a market, some ability to get protection. Next up. Attempted monopolization. So the reason you want to think about this is that you don't have to show the 65-ish% share of the market. You can show less. So if you're going to do that, next slide, you got to show that defendant engaged in predatory or anti-competitive conduct. So you got to show the defendant is doing bad things, whatever he's doing, and that he did so with a specific intent to monopolize. That is, the goal of this activity was to become a monopoly. And additionally, that there is a dangerous probability of achieving monopoly power. So the specific intent to monopolize, you can usually grab from emails, texts. We're gonna smash that rival, and there are all kinds of emails that sort of support these kinds of ideas of this requirement. The dangerous probability of achieving monopoly power is a more interesting one, because you've got to show, say you're at 50%, less than 65%, you're engaged in aggressive anti-competitive conduct. Does that arguably get you to a monopoly share of 65%? So you've got to show as a plaintiff that arc, some capacity to get to monopoly power. It's a demanding requirement, but it's just a little bit better than what you see in some of the other pure monopolization cases. Next up. I mentioned criminal stuff before. the U.S. Department of Justice recently, just actually in the last 5 months, basically secured an agreement. This is a classic bid rigging situation for cracked ceiling in 4 states for their highways. So Mr. Zito calls his major competitor and says, I'll get Montana and Wyoming, and you take South Dakota and Nebraska. And if we do that, then you'll have a monopoly in those 2 states, and I'll have a monopoly in these other states. The situation is that there is no attempted price fixing law under Section 1 of the Sherman Act, but attempted monopolization is an actionable thing under Section 2. And this gentleman recently pled guilty to criminal attempted monopolization in a, kind of a fact setting that is dramatically simpler than most of what we deal with when we're dealing with Section 2 cases, but it is a criminal case. Next up. Abusive dominance. This is just a smidge. This is a little bit of a teaser more than anything else. Next up. So more the resources here may be of interest. So remember, we have the power conduct paradigm here in the United States. Same deal kind of in Europe, but there are differences. The first one is that actionable market share for dominance is 40%. So dramatically less than obviously the 65% I usually feel like I've got to meet if I'm a plaintiff in a Section 2 case here. There are some potential trade restraints which are thought to be quite problematic. So the burden is already shifted to the defense. So it's a rebuttable presumption. I mean, that is the defense can say, no, this is good for the following 25 reasons, but the burden shift is already shifted. So this was I think you've already been lobbied to adopt some version of this. The question I think you want to ask if you are thinking about this, there's a fairly recent case, 2022 case, the most recent Intel case, in which Intel was able to rebut the presumption. The activities there were very restrictive, exclusive dealing requirements, and then straight payoffs to original equipment manufacturers if they used Intel versus ADM chips. So the broad press on this particular decision is that this decision brings the abusive dominance framework much more in line with US antitrust law. So if you're interested in this space, you want to ask a few questions, and that's a key question, I think, for you to ask in terms of how this actually works as it's currently being done in Europe. Next up. They do have something else which is interesting. There are certain hardcore restraints under the actual the organic statutes and treaties that basically created the EU Competition Commission. And the deal here is that if you are engaged in one of these activities, the burden starts shifted against you. You've got to show that this is pro-competitive and here's how you do it. So this includes things like vertical price fixing, exclusive contracts, and predatory pricing. So this is a really interesting space. And this list of things is kind of a list of difficult competitive things for rivals and consumers, but worth taking a look at, I think. So I think this is something that hopefully the lecturer that we'll get for you on EU law can explicate in greater detail with all of the specifics of how they actually litigate these cases. But this sort of notion of, again, this is a rebuttable burden of proof. So vertical price fixing in the US it's basically rule of reason. In California, it's per se unlawful. That is, it's unlawful if you show it. In this system, vertical price fixing would be presumptively unlawful, but a small competitor or whatever would be able to demonstrate that this is pro-competitive on a case-by-case basis. So potentially an interesting structure for you to take a look at. Next one. Okay, gaps in current law. Next. So gaps may be a little strong here, but so this is my sense of what California law looks like in terms of what we've just been talking about in terms of federal monopolization practice. Monopolization is contrary to California common law. So this Burdell versus Grandy, it's charming actually. If you get to West Marin, there's a really cool little town, Point Reyes Station. So that was originally built on land that was a Spanish land grant. So one person owned much of West Marin, and the person circa the end of the 20th century had the only bar in 40 miles. And so when he subdivided land, he included a condition that no one that bought land from him could create a bar. So this ultimately went to the California Supreme Court. This is a California Supreme Court decision. And the court said, no, monopolization, which is what you've just done, is contrary to California common law. None of those conditions can be enforced because they're contrary to the law. So that if you run into this situation, which would be unusual, that would be addressable under California common law. The Cartwright Act, which is the major antitrust act of California, speaks in terms of a combination of capital, skill, or acts by two or more persons, doesn't include single firm conduct. It might include something like a conspiracy to monopolize, because since you've got agreements by two or more people, but the classic single firm John D. Rockefeller situation, not actionable under the Cartwright Act. The unfair competition law, this is the one that allows you to cross-reference and use in California trial courts things which are unlawful in other jurisdictions. So you could bring over Section 2 of the Sherman Act using this prong of the unfair competition law. This does not bring over treble damages and other things that are associated with U.S. antitrust law. So you can kind of do it, but it's not a perfect analog. Finally, there's something called the California Unfair Practices Act. This deals with things like below-cost sales and things of that nature. You don't have to have a conspiracy to violate this act. So this could be a single firm tool, but one limited to very specific kinds of activities. So, this may be enough. You might say this is enough for us, that's fine, but it's not, doesn't do as much as might be possible under federal law. Next up. So this is just a very brief and hopefully not too quick perspective on monopsony. Again, this is not, a monopoly buyer of services kind of a situation, and buy-side antitrust generally. So next slide.
Professor, could I stop you for a second?
Yes, of course.
Just a scheduling timing question. I think we have a for sure beam in from Dean Chemerinsky at 11. So I'm just wondering what your time estimate is.
I think I should be done in about 6 minutes.
Super. Thank you.
Yeah. So very briefly, so you can be anti-competitive when you buy stuff. It's not just when you sell things. 1905 case, this was early on. A group of the big 6 meat packers basically combined to create a buying cartel to reduce the price of cattle that they were purchasing for their slaughterhouses. Similar kind of deal with the Mandeville Island Farms, sugar refiner buying cartel, per se unlawful. Something that's a bit closer to home, This is a merger case. The merger of two rice processing firms were enjoined, they're called millers, because that would increase the power of the combined firms to reduce the purchase price of rice from rice farmers in California. So these are buy-side examples of market power in action, which has been prohibited in the case law. Next up. Now, an area that I think you're going to hear a lot about, which I think is something that's important. So the first bit here is from Marita and Hovenkamp. This is, again, one of the leading treatises on antitrust. This Herb Hovenkamp, I think, is generally thought of as a pretty moderate analyst. Phil Arita has passed away, but it's still called Arita and Hovenkamp. He basically says that suppression of labor market competition is an area in which the antitrust laws are under enforced. So whether this will have application to your assessment of whether California antitrust law needs to be adjusted, or whether we as antitrust enforcers need to, at the state and federal level, need to increase our activities, that's something you will need to decide. But there's really interesting, this second piece, there's a really interesting economics work, which is to the effect that a lot of labor markets in the United States, there's a map in this article, which basically suggests that the labor market, that is the market for workers and specialty workers and things of that nature, is actually quite concentrated in the United States, and it has increased in concentration over time, and increased concentration in labor markets results in lower remuneration to people in those markets. So just really interesting. And then I like this article as well. One of the implications, at least according to this article, is that we may need to use new tools, which they suggest what they might look like in the context of cases we're already bringing, in order to address this now better understood increase in market power in the purchase of labor. Next. So there is currently a fair amount of action in this space. So a non-compete agreement is one in which an employee agrees not to take a job with a competitor of his current employer. Now, the good news for California is that this is illegal in California with some very specific exceptions. So one of the reasons, arguably, that we have been so productive in terms of technology is that engineers are able to move from one company to another historically, and they cross-fertilize. So we've been able to do tech faster than other places in the country. And one aspect of that may be the fact that non-compete agreements are illegal in California. But this is not true in the rest of the United States. This second piece is from the FTC. One aspect of these kinds of things is that it's not limited to doctors, engineers, scientists. This is a non-compete for security guards. And if you work for this Prudential Security, you couldn't go to work for another security company within a 100-mile radius of where you lived. So these powerful contracts, powerful limited contracts, are being applied to very modest levels of employment. One consequence of this is that the Federal Trade Commission, which has rulemaking power, the U.S. Department of Justice arguably doesn't, they clearly do. Lena Khan has proposed a national trade regulation rule, which would look presumably a lot like California's current law. So non-competes are being used a lot of places. They preclude people from going across the street or 2 towns over to get a better job. So they have really quite extraordinary effects. Next one. So another kind of interesting thing are no-poach agreements. So no-poach is I enter into an agreement with my competitor, my rival, that I'm not going to poach or try and employ its workers. So the seminal first major case, and this is a local deal actually, United States versus Adobe Systems, multiple technology companies agreed to not cold call, that is recruit employees at other technology companies. So this involved Google, it involved Apple. I mean, every major tech firm was involved in this. A settlement was ultimately reached with all of these firms, injunction against further illegal conduct. That was followed by the second bullet, which is a class action that was entered into class action on behalf of the various engineers and other folks who were subjected to this no poach agreement. And that was settled for $415 million. So, you know, obviously a good result for the engineers that couldn't go across the street from, you know, Adobe to Apple and get a better job. This has also been attacked criminally, this United States versus He. This is a case in which healthcare company pled guilty for suppressing the wages of school nurses, and there was also an aspect here of no poach. So they, you know, the competing firms that supplied nursing services had agreed not to try and grab or recruit the nurses that worked for their competitors. Next up. Wage fixing, this is just pure price fixing, but applied to purchases. And there's some cases that are basically in that frame. I was looking at my feed this morning from the Department of Justice. DOJ just indicted, just made public today, another wage fixing case in Las Vegas concerning healthcare workers. So the Department of Justice is focused on this, as is the FTC. This 2016 thing down at the bottom, antitrust guidance to HR people explaining how the antitrust laws affect sort of ordinary course things like agreements on wages, no poach, et cetera, and the dangers that are associated with that. So this is becoming an increasingly active area of antitrust jurisprudence. Next. Mergers. We also have included in mergers effects not just on the sell side, but on the buy side. The most interesting, most recently, is the Penguin Random House proposal to buy Simon & Schuster. So the focus here was not on the price of books, but on payments to authors. So you may have seen this in the press. A major horror author was, you know, one of the key witnesses. And so the question was, would they suppress advances, which are payments made to authors while they're working on books? And the court concluded that this merger would have reduced the ability and reduced competition for authors that are expected to sell lots of books. And so this is a buy side, essentially employee professional kind of focus in a merger context. United States versus Anthem, the alternate theory that the government brought to this case was that it would affect not just the price of healthcare services, but that it would control the ability, you know, suppress potentially wages and recoveries by hospitals and doctors and nurses, et cetera. So these merger cases are beginning to include explicitly wage side concerns. And this is a new frontier. There's lots of new work that needs to be done here, but this is starting to happen. And I'm sure that you're going to hear a lot about wage fixing, no poach agreements, et cetera. And mergers that may affect employees. This, of course, raises the question, there is no merger except through the unfair competition law in California. So that it will implicate whether or not you want to do that in the first place. And then if you do want to do it, you want to provide some guidance in terms of how courts in California should address these kinds of issues. Next up. Next. I think that's it.
That's great. We have 5 minutes.
Okay, and you might also want to approach here just to be aware. My role is not to suggest to you what you do, but there is already a state statute specifically on no poach. I've given you a Canadian example of a specific statute that says no poach is illegal and wage fixing is illegal. And the last slide, which should be any questions?
Any questions from my colleagues? Brian, can you stop the share?
Question, but I
Going
just want to
once.
say, Professor Green, it is so great to actually listen to your presentations. They are so thorough and you're detailed and breaking down all these really kind of sophisticated concepts. I always come and learn so much from you. So thank you so much for your presentation and your contributions.
Oh,
Rick looks like he has his hand up.
made my week, actually. Thank you very much.
Go ahead, Viceroy.
Yeah, I would echo what Soshi just said, but a quick, probably naive non-lawyer question. Does the federal government, in all these sort of anti-competitive kinds of activities we've been talking about, does the federal government have jurisdiction over cases even that don't involve interstate commerce? I'm thinking about the federal law versus California law. Should we?
Very interesting question. Yeah, historically, when the Sherman Act was first enacted, there was this barrier. There was interstate commerce and there was intrastate within the state of California commerce, and the two did not interplay. But that's no longer the case. I mean, for example, even in a simple bid reading case, I do need to show that there was some impact on interstate commerce, but that can be proven by the fact that mails were used or they bought stuff from, New Jersey and in order to, build a better hospital system or something. So it's almost you tag that base, but it's so easy to do that it's not that huge of a deal.
Okay.
So, but certainly an important question to ask. And it's also the case that whatever you do with state law, you could affect stuff in New Jersey too. I mean, that also is an aspect of this largely dissolving of the barrier between interstate and intrastate commerce.
Great. Thank you. I appreciate that.
Yeah.
Anything else from my colleagues? Going once, going twice. That being the case, Professor Green, always a pleasure. Thank you so much.
Thank you very much. I'm obviously leaving you in great hands with the famous Dean Chemerinsky. So good stuff. See you next time.
Thank you, Professor. Brian,